Good afternoon. Call the case of number 125092. Faith Rivera et al., Tom Alonso et al., Susan Frick et al. As appellees versus Scott Schwab in his official capacity as the Kansas Secretary of State, Michael Abbott in his official capacity as the election officer of Wyandotte County, Kansas, as appellants, and Jamie Hsu in his official capacity as Douglas County Clerk. With that, will council please state their appearances? Thank you, council. Those that were here this morning are already aware of the empty chair, but there may be new individuals in the courtroom who are not watching this morning or are watching our live stream at this point. Justice Eric Rosen has tested positive for COVID and so is in isolation and following our isolation protocols. He is listening, watching through the live stream, our oral arguments today, and he will be participating with the court in decisions. We will be conferencing this case remotely with all of us through virtual technology. For those counsel who were here this morning, we do have a clock back, so that should help us with regulating our arguments this afternoon. And with that, we're ready to begin.
Good afternoon, Chief Justice, and may it please the court. I'd like to reserve 15 minutes of rebuttal time.
15 minutes is allowed.
Thank you. This case is a state constitutional challenge to the Kansas Legislature's redistricting legislation, creating new districts for members of the United States House of Representatives. Case comes to this court on appeal from an unprecedented district court decision. For the first time in Kansas history, a court has invalidated a congressional districting map duly enacted by the legislature, holding that partisan gerrymandering violates assorted provisions of the Kansas Constitution, which have never before been applied in this way. A brief word about language. In this case, we are going to talk openly about Republicans and Democrats, because plaintiffs' constitutional theory puts party politics at the center of this case. Normally, when I'm here, the discussion is purely in terms of principles of law and perhaps some facts from the record. This case requires us to talk in terms of party politics and the winning and losing of elections. This very fact should give the court pause. Congressional redistricting is political by design. The United States and the Kansas constitutions wisely entrust this task to the political actors in the Kansas legislature. The legislature, not the state judiciary, is designed and equipped to make the political determinations that cannot be avoided when drawing district lines.
Council, let me interrupt. So these maps are the product are in legislation. They were enacted into law, right? So that's government action. And what keeps going around in my head here is how we accept this, seem to accept this notion of Republicans and Democrats fighting, you know, kind of boys will be boys sort of deal. But how is partisan gerrymandering ever a legitimate government interest on which government is acting toward its citizens?
I don't think there's a strong argument that partisan gerrymandering is a legitimate government interest. But I think the point is that it is a collateral effect of the way in which the various constitutions have allocated the power. The US Supreme Court and this court have both recognized that politics is part of the process from the very inception of how it was designed. And it can't be distilled from the process because it's being done by politically elected actors and concerns a political outcome. So I think it's perhaps looking at it from the wrong direction is one manner of saying.
Well, I mean,
that.
I've got a, you know, we can all find quotes, but I've got a quote from a US Supreme Court case that says, desire to harm a politically unpopular group cannot constitute a legitimate governmental interest. Seems to be at play here because, like I said, I'm not looking at this as Republicans doing this to Democrats or to independents. It is government targeting other citizens to do the map, however they're going to do it. And so it seems to me that how we look at this as government action toward our citizens is an important prism with this. And it gets back to the question I asked the Attorney General this morning about invidious discrimination, which is a phrase that's used quite a bit by the Kansas Supreme Court cases that deal with state and House legislative districts. It seems to me the same thing would apply here. I mean, if the legislature was concerned about the Catholic vote, and so it put into the design of a map ways to dilute the Catholic vote, to scatter the Catholic vote out among various districts, would that be constitutional?
I don't believe that the Supreme Court or this court has ever reached the point of injecting a religious question into redistricting. There have only been two exceptions so far, and that's one person, one vote, and that's racial. I could envision a case where if there was specific direct evidence, in other words, the legislature, the members of the legislature all gave speeches reflecting invidious religious discrimination, that it might be an incident where the court would carve out a third exception. But the difficulty with that hypothetical in this case is, where does it stop? In addition to the two recognized exceptions, this case argues for a new exception based on political party. And the plaintiffs have argued that there's a certain logic to that because we're talking about elections. But the fact is, they're arguing for the third exception. What will be the fourth? And what will be the fifth? Will it be age? Will it be gerrymandering based on religion? Will particularly sensitive or important political issues divide the population such that a certain number of people who support or oppose an issue claim that they're entitled to some kind of proportionality in the redistricting?
But why not just approach this like we do the First Amendment and say, you know, is it content neutral or is it content related? And if it's content related, you've got one standard. If it's content neutral, it's another. And, you know, courts are able to do that. And just seems to me like this is government action targeting other Kansans for how they're treated in this map redesign.
First of all, the analogy to the First Amendment seems inapt, because there you're looking at the content of the speech. And it's a relatively straightforward determination of whether something is content neutral. Courts have a great deal of experience in doing that in the context of the First Amendment. The fact is there is no historical experience in articulating a test for political gerrymandering. You pointed this morning and a few moments ago to some of those original cases, I think the two 1979 cases after the constitutional amendment was first passed. Both used the words either partisan gerrymandering or political gerrymandering, but neither of them articulated a test. And if you read on, both of those cases essentially rejected the concept almost out of hand. In the second of those cases, the court referred to political considerations are something that varies based upon the issues and the candidates. And in the first of those cases, the court said that it was essentially an equal protection argument. So we think the difficulty would be in standardizing or devising a test, which is why this is essentially a political question that the court should not be entering into.
Is there any point at which partisan gerrymandering in your mind would be unconstitutional? Ever?
I don't believe so under the Kansas Constitution, certainly not under the federal Constitution. And that sometimes that's used as a basis for saying, well, then it's open season on voters. And the fact is that's not the case because there are many other avenues by which the issue can be addressed. The United States Congress in the Elections Clause reserved for itself the right to address these issues. And in fact, over time has addressed them. Historically, many states had at-large districts, and as early as 1842, to avoid political gerrymandering, the Congress of the United States required single-member districts, and that law is still in place.
So if here the legislature would have, and this is a hypothetical, made serpentine snake-like throughout, the first district was snaky, and the second district was snaky, and the third and the fourth. And it was all, the result was clear that it was based on partisanship, or there were facts to support that it was based on partisanship, then that would not be unconstitutional in your mind.
No, I don't believe so under the Kansas Constitution, which doesn't address the issue. There are other ways in which our political and legal and government system would address that issue, unless, of course, well, one of them being the possibility of amendment of the Kansas Constitution. Many of the states, including many of those that are cited in the briefing in this case, have passed constitutional amendments. The Florida Fair Districts Act, the Ohio Constitution, which many say Kansas was based upon, had a recent amendment to allow review of political gerrymandering as a constitutional issue. But the current version of the Kansas Constitution, we do not believe could be read to address that situation.
Counsel, while we're on the topic, I have what might be a dumb question. But it seems really important and to be glossed over by everyone. Can you give a definition of political gerrymandering?
No, I cannot. It's in the eye of the beholder, and that's one of the difficulties in this case.
Well, let me ask maybe an unusual question. What do you think your opposing counsel would say is the definition of political gerrymandering?
They would say that it's a dilution of the vote of a certain disfavored group.
And what does that mean? And this is what I want to probe into a little bit. Is there the term is obviously thrown around a lot, partisan gerrymandering. Does that mean that in one particular district, the percentages of party affiliation are substantially different from the overall percentages within the political district, in this case being Kansas? Is that what it means?
Well, so in criticizing it in the Russo decision, the US Supreme Court said there is a gravitational pull towards proportionality in arguing about gerrymandering, because at bottom, it is an argument that there is a certain proportion of a certain political party, and that political party is entitled to representation in that proportion.
And then so that, I guess, leads to my follow-up question is this kind of like a game of dominoes, if you will, where if there's disproportion in one district, doesn't that by a matter of math and logic mean that that political party is overrepresented arguably in a different district?
Well, again, it could be looked at in several different ways, and not to make arguments for my opposing counsel, but they might say you would look at the entire state and say that, well, Kansas has enough Democrats that it should have at least one or two of the congressional seats.
I guess what I'm
rather than-
asking a more basic question, which is this all about proportionality?
Yes, at bottom, we believe that it is.
And could it, if that's the case, does the Constitution have any sort of dictates in it about maintaining a party affiliation proportionality that's roughly equivalent to the state's proportionality? In other words, each district, I don't actually know what the numbers are off the top of my head, but let's just say there's, two parties and it's a 55-45 split. Does that mean each congressional district should be roughly 55-45?
No, that
It would seem to me
concept
your
is-
opposing counsel, that wouldn't benefit the minority party any.
Arguably, it wouldn't. And certainly these principles have never been applied across the federal level to argue that there should be some national proportionality, because of course, districting is committed to the states individually through the state legislatures.
Why can't this also be about political retaliation, or just say government retaliation? In other words, you make decisions based on how people exercised their constitutional rights in the past, how they voted in the past, or how they politically associated, Democrat or Republican or whatever. And you then take action against those people based on what they have done in the past. Isn't that government retaliation?
No, I don't believe so. And there for two reasons. First of all, I think when you originally stated the question, you said political retaliation and then said government retaliation.
But it's
The
the
issue-
same thing. But it's the same thing here.
It is.
We can't. This is government action. The supermajority got a law enacted, and so this is government action. And that's why
Government.
it's looked at that
It's
way.
government action in the realm of politics. And when your honor states that there's some sort of a vendetta based on how people voted in the past, no one can predict how people will vote in the future. To say that this is some sort of a retaliatory claim is simply wrong. Redistricting is committed to the legislatures by the federal Constitution, and it has always been committed that way. And there's no basis for saying that this is some sort of revenge or retaliation. It's politics. And there are winners and losers in politics. And some people come out on the longer end and some people come out on the shorter end. And then what happens is they run on that basis and they turn around and they make an issue of it in politics, and they try and change the members of the legislature, or they try and change the Constitution, or they try and change federal law through their congressman to change the process. There is no legal basis to say that because politics has resulted in someone being a loser, that there suddenly is a constitutional right
Well,
involved.
why was Johnson County kept intact?
So that was a matter that the legislature exercised its discretion. They were in a situation where, because of population growth, Wyandotte County and Johnson County could no longer be together in the same congressional district. And by the way, everyone concedes that in this case. That's not an issue. So they were confronted with a limited number of choices. You could split them both. You could split one or the other. Ultimately, they decided, based upon their discretion as members of the legislature and the arguments and the concepts that were presented to them, to split Wyandotte County. And you'll see in the record, the members of the legislature that articulated reasons, and they're in the legislative record, said, among other things, that Johnson County was considered the economic engine of Kansas. And a group of chambers of commerce asked them not to split Johnson County. Again, it was a discretionary decision.
But presumably for a good, for a good reason. There was some benefit that falls to Johnson County by being kept intact.
Well, so that goes to the allocation of communities of interest in connection with redistricting. And we believe that the experts in communities of interest are the members of the legislature. They are the ones who are elected in those districts. They know their constituents. They know the local culture and economy. And in this case, the members of the legislature exercise their discretion to say, we think Johnson County should remain together. The reasons I just articulated, they thought that it was an economic engine. There was also some discussion to the effect that given growth in 10 years, it may be that Johnson County has to be its own district. And better not to split it now than to have to bring it back together in the future. So there were those reasons that are in the legislative record. But I'm reminded of the fact that, of course, legislatures, when they're exercising their legislative discretion, they're not necessarily a court. They don't have to issue an opinion. They have to take a vote and run for re-election. And in this case, that was their considered judgment in allocating the real estate that had been previously part of the 3rd district.
Council, can I back you up? We're kind of talking about the substantive merits, but as I understand your position, there are 2 threshold questions as to whether or not our court even has authority to interject itself into the review of this case. One, you've touched on the political question doctrine, but your other argument on the elections clause, my understanding is that your position is that forecloses our Article 3 powers of review in this situation. But does Arizona State Legislature, I mean, they pretty clearly indicate that state constitutional provisions have a role, which also implies a role for our court in exercising its powers. Can you explain to me why more recent U.S. Supreme Court authority hasn't really dampered your argument on that elections clause?
Certainly. So we think that the best view of the elections clause is that it only includes the state's prescriptions for lawmaking, a term that's been used in those cases, and I believe in the Arizona case as well. In the Arizona case, the people had voted to put in place a redistricting commission. And what you find in all of those elections clause cases, many of them cited in the Frick brief, is that in those cases, the state had defined lawmaking to include certain elements in addition to the legislature. So the lawmaking process included, for instance, the veto power of the governor, as we have in Kansas. In other cases, it has included the local referendum to allow redistricting commissions. Kansas has nothing comparable to that. And the prescriptions for lawmaking in Kansas end essentially with the legislature and the governor's power to veto and the legislature's ability to override. The U.S. Supreme Court, as recently as the last couple of months, has garnered 4 votes indicating that they would grant certiorari in a case raising these very arguments. So we think that it is very much a live issue and that our view of the elections clause is the correct one. It does not, the lawmaking power does not reach in Kansas on the legislature and presentment to the government. The Supreme Court is not a lawmaking body, it's a review body. And in this case, that power is not part of the prescription for lawmaking.
I guess I have a couple of follow-ups to that. First, hasn't our court historically viewed the state constitutional Bill of Rights as a check on Article 2 or legislative powers of lawmaking? And why, I mean, you say it has to be a state constitutional provision that governs the lawmaking process, but isn't that what we have construed our Bill of Rights to be?
In many cases, yes, the legislature, the court reviews for constitutionality acts of the legislature. This is a very unique enactment. It's enacted pursuant to the direct authority, not of the Kansas Constitution, but of the federal Constitution. And therefore, we believe that the elections clause provisions attach to it in this unique situation.
So if the legislature passed a law that said in congressional elections, only white male property owners get to vote, Kansas Constitution has no role reality of that legislation.
Well, of course, that would easily be unconstitutional under existing law from the United States Supreme
I'm
Court. and
only
it would-
asking
It would
about.
never get here.
But my question goes to the state constitutional provision. Are you saying that if that happened, the Kansas Constitution has no part in challenging that legislation?
Of course, I'm not. As I've indicated, there are the two exceptions in Rusho that were articulated that courts accept that this court has applied in its state redistricting cases. One man, one vote, and racial gerrymandering issues have clearly been reached by this court and by the United States Supreme Court, which explicitly said they're the two exceptions that courts can get into in regulating redistricting.
But if you take out Justice Biles' race issue and just made it gender and property owners, you would not believe that we could address that under the Kansas Constitution?
There have been no exceptions created either at the federal or state level for those. And of course, that's the question presented here today. The plaintiffs are arguing for a third exception, political gerrymandering, political party membership. And so what next? What additional suspect class will be able to claim that it's entitled to proportional representation? Now, we're not talking about sort of election or poll restrictions. If the Kansas legislature passed a provision that said there's a poll tax based on sex, that would clearly be unconstitutional. Redistricting is a different natured animal. Here we're talking about whether someone is entitled to vote in a way that they can achieve certain results. In other words, Democrats want Democrats to win. Republicans want Republicans to win. And to use your hypothetical, say if women wanted women to win. And that concept of proportionality has never been imported into the Kansas or the federal Constitution outside of one man, one vote and racial gerrymandering.
Could you, if you didn't want to look at it as a proportionality issue, because I think that the appellees frame it a little bit differently, but if you look at, our equal protection, Section 2 of the Bill of Rights in the Kansas Constitution, that kind of analysis is triggered when people similarly situated are treated differently or classified. So equal protection review applies when a law affects the rights of, one person that's part of a group. So I don't know that it's necessarily outcome oriented. The question is whether or not equal protection is triggered by drawing lines based on political affiliation.
And there's certainly no precedent in Kansas for applying the Equal Protection Clause to protect a minority political party.
Well, I think that's why we're here.
Well, that's true. It would be novel and groundbreaking and would separate this court from the many other courts, including the U.S. Supreme Court, who have found that that is not a basis for a claim, which is why, of course, we are here arguing that this is not a justiciable claim under the Kansas Constitution.
Well,
I think
whether it's justiciable is a different issue than actually applying the equal protection, right? Because justiciable, we look at whether or not we can even entertain it, correct?
I think they are separate, but they are adjuncts of the same point. Fair to say. You have to find that it's justiciable first, and then if it is, you've entered the issue of determining, well, what is the equal protection test? How do you determine that there was partisan gerrymandering? What's the test? And of course, that gets you into the weeds of determining the various merits of the political maps and the line drawing process, and substituting essentially the court's views for those that were put in place by the legislature.
On the issue of political.
I'm glad you
question.
did that first and not me, because we thought I was going.
That's what I'll call it. Isn't deciding whether there are any judicially discoverable and manageable standards for purposes of deciding whether it's a political question, actually judicial review of a political question in and of itself?
Not when there's nothing to guide the court, as we contend that there is here. And in fact, here we contend that it's actually inconsistent with the history and substance of the Kansas
But
Constitution.
aren't we actually going into, if we're trying to decide whether or not there are standards, aren't we already weighing in? Isn't that judicial review?
Well, so the fact that you have to go about this searching process of trying to create standards is an indication that should deter one from entering into the process to begin with.
But there are states that have standards, right?
There are states, and I think if we look closely at those, and we've cited many of them in our brief, you'll find that those states uniformly have unique constitutional provisions that govern redistricting. Those states, typically their lead holdings are based on nonpartisan redistricting commission provisions. Those states have anti-political gerrymandering provisions that are literally written into their
Right, but some
constitution.
states don't.
I don't believe you'll find any state that's made a decision to allow a review of political gerrymandering that has the same or similar constitutional provisions to Kansas. If you look at North Carolina, it has a unique free and fair elections clause. If you look at Florida, it has the redistricting fairness constitutional amendment. Certainly those cases sometimes go on to cite sort of this assortment of constitutional provisions, and they say, well, we have our redistricting provision, and it's also a violation of the First Amendment or the right to vote or what have you. Kansas doesn't have a unique redistricting constitutional provision. Certainly it has a right to vote. No one's right to vote is violated here. Everyone is allowed to vote. No one's First Amendment rights are violated here. Everyone's allowed to speak and campaign as they wish.
What about assemble?
Entitled to assemble as they wish. This doesn't interfere with the right to assemble in any way.
And in the Kansas Constitution here, I had to print it off because we don't have being able to assemble and petition the government and instruct representatives. That's in Section 3 of the Kansas Bill of Rights.
That's not infringed in this case.
Can you tell me what your construction is for KSA 25-125 subsection D and how that might apply to the question of justiciability? I believe that's the statute. Subsection D of that statute suggests that nothing in the Elections Act limits our Article 3 power of judicial review.
We don't believe that provision has any effect upon this case, either the elections clause or the non-justiciability arguments. That recently added provision, certainly wouldn't affect, like for instance, the case that you heard this morning. And it certainly wouldn't affect other cases that are currently percolating in the district courts about various voting and election procedures. But
based on the timing of the passage, or is that?
No, but based on the language of the statute. Again, I would come back to the difference here is this is federal congressional redistricting pursuant to an authority granted by the United States Constitution and not under this Kansas.
In terms of our standard of review, you pointed out on page 27 of your opening brief that the district court judge in this case was an elected judge affiliated with the Democratic Party. How are we supposed to factor that into our analysis? What factors play into it if it was an elected Republican judge or a judge who was affiliated?
So we of course, first, we mentioned that several points in the record. We first mentioned it when the case came to this court the second time on the question of consolidation and what judge should be assigned to the case. We think it is a relevant fact that the case was decided by an elected partisan judge. how does it factor into the standard of review? I don't think it necessarily changes the standard of review. Consider the totality of circumstances of the facts in this case. That's certainly one to be aware of. As we know, Kansas has in its district judges a division between the commission selected judges and nominees and partisan elected judges. And it's the case that in this case, the plaintiffs chose to file the case in a district where the judges, partisan elected judges, and are all members of the Democratic Party.
But we've got to look at the findings of fact based on whether they're supported by substantial competent evidence. How the judge was elected play into that? I mean, you brought it up in your brief in this. I'm just trying to figure out how it plays.
I think it plays as part of the totality of the circumstances in the analysis. The district judge in this case basically wholesale adopted the findings of fact and conclusions of law that were submitted by the plaintiffs. Both the submitted version and the entered version are available in the record for the court's comparison. He essentially made virtually every ruling on contested issues of fact and law in favor of the plaintiffs. So again, that's something that's part of the totality of the circumstances as the court reviews the lower court decision.
Just real quick on the the fact findings on racial gerrymandering. What is your position as to either why substantial competent evidence does not support those findings, or why those findings are not legally sufficient to support the conclusion of racial gerrymandering? Can you just sort of summarize where you're hanging your hat on?
Yes, I'm glad. Our position is that the plaintiffs did not meet the legal or factual requirements for their arguments of racial vote dilution and racial gerrymandering claims. First of all, there was no direct evidence of intent, which is required by the applicable law. They did not submit any evidence that the legislature enacted this particular provision because of anyone's race. Several Democratic members of the legislature testified, and when they were asked on cross-examination, do you have any understanding that there was a racial intent on the part of the majority? They denied it. Furthermore, when you look at the effect, you will find that minority voters have essentially the same voting percentages under the new map as they did in the old District 3 and new District 2 under the new map. In old District 3, the minority percentages were 32.4%. Many of those voters in Wyandotte County above I-70 were moved into District 2, and the new District 2 is 30.2%. That is only a 2.2% difference. So those voters remain in a similar proportion, in a similar percentage in their new district as they were in their old district. So those minority voting percentages are
Counsel,
essentially the same.
does it matter where those people actually live, or is it sufficient that they live in the district?
Following your
Well,
question.
you may have percentage in a district, but for example, the actual people are much more spread out, or they're in different places, or they're not close to the same people that they were close to before in what might be considered a community of interest in the previous district.
Well, so certainly we think that that matters in the sense that it's within legislative discretion to consider those issues. But here, having decided to draw the line where they did, the way the plaintiffs have tried to present that issue is that the individual minority voters were previously in a crossover district. In other words, in the third district, there were more non-minority voters who would vote the same way as the minority voters than there are in the new second district. And that theory has been rejected by the US Supreme Court. There's no right to remain in a district with other voters who think or vote like you as a minority voter.
So your position is that just looking at the district is sufficient. And the percentage of minority voters simply within the district, disregarding any potential crossover.
Yes,
interests.
that would be our view, that the percentages, and then as the percentages here are essentially the same, the minority percentages in the old third versus the minority percentages in the new second, those minority voters still have the same percentage voting power, and the law doesn't require anything additional.
What findings of fact do you believe this court would be bound by in the district court decision?
Well, we don't think that the court should reach the point where it's reviewing the findings of fact. We think that the court should find that there is no basis for a Kansas court to litigate a political gerrymandering claim. If court finds that there is a right to a political gerrymandering claim, then it would be substantial evidence.
But how would the court look at a racial gerrymandering claim without looking at the facts?
And moving to, you're right, Your Honor, on racial gerrymandering, that's absolutely correct. Here it is a mixed question of fact and law, and certainly the facts that I have just cited from the record about the voting percentages, and the additional testimony, those are well within the court's ability to consider.
And finding yourself then to that issue, which findings of fact do you believe the court is bound by?
I believe the court is bound by findings of fact. I believe the court gives them a certain amount of deference in connection.
If
with
there's
reviewing.
any evidence to support them, and I understand there's competing evidence, but the court made certain factual findings. And are we bound by those then if they reference race?
If they meet the standard of review of the substantial evidence on the record. I mean, I'll give you an example. There was a finding regarding evidence of intent. The plaintiffs presented an expert witness who gave historical evidence about racial history in Kansas. And this expert witness testified that when I-70, Interstate 70, was built in 1956, it was located based on racism. Now, that is a fact in the record, but as a legal matter, racism in 1956 doesn't translate to racism in 2022. So the court considers that fact in light of other facts in the record that were in the cross-examination of that expert witness.
Do you believe there are any findings of fact that have no basis in the record?
Yes, we actually believe that the artillery battery of expert witnesses presented by the plaintiffs are largely beside the point and of no value to the court. That's because on their own terms, these expert witnesses disregarded many of the elements of the guidelines that they claimed to rely on. There's been discussion in this case about the guidelines that were adopted by limited subgroups of the legislature, but have never been enacted into law. The experts relied very heavily on those, but interestingly enough, they chose to ignore the ones that could not be quantified and put into a computer system. So if you look at those guidelines, a very important element of them, it's 4 sub B, was the recognition of communities of interest, social, cultural, racial, ethnic, and economic interests. And none of the quant experts, which was most of them of the plaintiffs, considered any of those factors because they can't be quantified and fed into a computer. They looked at things like compactness, which can be graphically measured and used for a computer system. They looked at things like being contiguous, which is simply that the districts aren't in separate blocks. But all of them looked the other way when it came to those community of interest factors, which frankly is an important element of our argument here, because only legislators or individuals who have familiarity with those areas, they live there, they campaign there, they have businesses there, they have families there, can evaluate those factors. No expert can evaluate those factors in the same way that a legislator can, and certainly their experts did not here.
Your discussion with Justice Wilson touches on a point of some tension when we apply our standards of review, which generally are that matters of intent are left to triers of fact, but we then overlay that with a substantial competent evidence situation. How do we really separate that? I mean, are we inevitably reweighing the evidence if we try to unwind or dissect the various pieces of evidence that go into a factual finding of intent?
I'm aware of the tension, and I think that almost inevitably, yes, you are. You are rejudging the case. In this case, you are rejudging the considered judgment and discretion of the legislature when you do that.
And are we also doing that with the court judge's determination of some racial gerrymandering here? There was an intent to do that.
Yes, yes, I think that.
Are we left with that conclusion, that finding?
No, I mean, in other words, are you bound by that finding?
Not bound, but inevitably, does that tension lead us to the road of saying we can't unravel all the elements that go into that finding by the judge and we defer to it?
I don't believe so here. I believe that this court has the ability to look at the various facts. There were, I just gave the example of whether I-70 was a highway built with racial animus. There's evidence in the record about the date that occurred. The court can consider all of that, the cross-examinations of those experts. Those are the elements of intent, but the court, there's no element, especially with an expert witness of the district judge evaluating the credibility of the witness. It's a pure expert testimony situation.
Just real quick to clarify, in one of your answers over the last few minutes, I thought you said that there was no direct evidence of intent here, and you have to have direct evidence of intent to prevail. You're suggesting circumstantial evidence is, as a matter of law, inadequate to support a finding of intent?
Yes, I believe we make that argument in our brief and have the citations.
And based on what authority?
I believe we cite a U.S. Supreme Court case, intent for racial discrimination. Good. I see my time is expired.
Okay, thank you, counsel. Brett?
Good afternoon, Madam Chief Justice, and may it please the court. I'm Sharon Brett from the American Civil Liberties Union of Kansas. I'm going to be presenting argument today on behalf of the Alonzo and Rivera plaintiffs, but as we noted in our statement of oral argument, specifically to our claim of racial vote dilution and the justiciability and merits of our partisan gerrymandering claim. And then my colleague, Lali Maduri, will speak specifically to the defendant's federal election clause arguments. The Kansas Constitution's Bill of Rights begins with distinct and essential proclamations that all people have equal rights, that all political power is inherent in the people, and that government is here for our equal protection and benefit. In the Harris case, this court said that sections 1 and 2 of the Kansas Bill of Rights mean that all Kansans should have equal power and influence in the making of laws that govern them. Racial vote dilution and partisan gerrymandering are antithetical to these core constitutional principles, because a map that engages in these invidious practices by its very terms gives equal protection and benefit only to some people, not to all people. It classifies and favors one group of voters over another, and it distorts and manipulates the map to advantage those in power.
Let me ask you, given what you just said, heard me talking about invidious discrimination the whole day. I'm not a very creative person, and so all I can do is I kind of look back at Kansas Supreme Court cases, see what they've said in this area, and then gone from there. By focusing on invidious discrimination, that too myopic from the argument you're making? I mean, I'm trying to get at, there's a lot of argument about, this case is about ensuring that Democrats have a certain amount of political muscle in the next election. And in my mind, invidious discrimination is basically punishing people for how they've exercised their votes in the past or how they've assembled in the past. It's a retaliation kind of thing. So I'm trying to figure out if that's where I'm focused. Am I looking too narrowly at the universe of evidence from what you're trying to argue? Does that make sense?
Sure, and perhaps it's good in response to that to back up and talk about what are we talking about here? What actually happened here? And I believe the question was posed earlier, what is partisan gerrymandering, right? So there's two distinct claims here, racial vote dilution and partisan gerrymandering. And I do want to make sure I talk about both. But on the partisan gerrymandering front, what we're talking about is the intentional entrenchment of power in the majority party in such a way that it effectively deprives the disfavored party of having any power or influence at all in the laws that govern them. And that's what runs contrary to the equal protection principles that are outlined in sections 1 and 2.
How does that work, practically speaking? In other words, let's say we were in a totally different context and I was a bad legislator and I said, I want to do this. Like, how do I do this?
I'm not
What you just described. In other words, it's back to that proportion. There's only a certain number of voters in a state, and I get the cracking and packing and all of that. I'm familiar with all the terms, but at the end of the day, a person is a member of a party that doesn't have enough votes. And I'll go back to maybe I talked this morning about my friends in maybe the Libertarian Party or Green Party. Are their constitutional rights just being violated all the time because they can never elect their candidate of choice?
What we're talking about here is the specific categorization of voters based on how they vote and treating them differently, treating similarly situated individuals differently in violation of equal protection, right? So in a two-party system, obviously, you're looking at Democrats and Republicans. There are individuals who vote for third parties. But here, what the map makers did and what the district court found by substantial, overwhelming evidence is, I believe how the district court put it, is that the map makers set out with the intention of drawing an entire political party out of power, a party that had the ability to elect a representative of their choice previously, and now under the new map does not. So that's the sort of intent that we were talking about and that the district court found here.
From how you described the right or the issue, I'm not sure which we're talking about. And that's what I kind of like to unpack. What is the right we are talking about here, the constitutional right? Does it oversimplify what you were seeking to call it the right to vote?
So we, as Your Honor knows, we point to a number of rights that partisan gerrymandering violates
So we
in the
have
Kansas
to take
Constitution.
that constellation of different, we cannot rely on any one section to get to where you need, where you're asking us to go. We really need to look at all of the different arguments that you've made, all the different constitutional provisions you've cited, bundle them together to get the right that you're asking?
No, I believe that the district court's reliance primarily on section 1 and 2 of the Kansas Bill of Rights is what's doing a lot of the animation here. Those rights guarantee equal protection. And as I just noted, a partisan gerrymander by its very terms denies a group of individuals of equal protection, equal power and influence in the laws that govern them based on who they vote for.
So let's unpack that a little bit.
Sure.
Starting with section 1. What is the natural right that you are alleging is being protected?
So we are, as you can probably tell in our briefing, section 1 and 2 are working in operation with one another here. And the right to vote is essential and is within the Kansas Constitution itself. But Section 2's specific description, looking towards equal political power, all political power being inherent in the people and instituted for their equal protection and benefit, combined with a statement in Section 1 of all individuals being possessed of equal and inalienable natural rights. These two things in combination with one another, when we look at what happened with this particular map, we can see just on its face how it violates those principles because of how it treats similarly situated groups of voters differently.
How does it treat them differently? They all get one vote. Every person gets one vote. How is that different?
So I think here, looking to the language of the Harris case is instructive. And thinking about how the right to vote is not just the right to cast a ballot. The right to vote is the right to vote with meaning. Now, that doesn't necessarily mean being able to be successful in your vote in every given election. But when the legislature sets out, has the intent and effectively accomplishes the intent of making sure that one group of voters' votes mean less than another's, that is where—
What does it mean to say means less?
A partisan gerrymander by its very nature is deliberately entrenching one political party in power and making sure that the votes of the disfavored party are diluted such that they will not have the same opportunity in the districts that are drawn to elect their representative of choice. And that's what we saw happen here. That's what the factual findings from the court saw.
What constitutional clause gives a citizen the right to an opportunity to elect a candidate of their choice? Well, what does that really mean?
Again, pointing back to the language of Section 2 here of the Kansas Bill of Rights, when we talk about a government that is instituted for the equal protection and benefit of all people, and all political power being inherent in the people, then each individual should not have their votes relegated to not matter simply because of who they vote for.
Well, some people's vote, I guess where I'm having trouble making the logical connection with your argument is that there are certainly individuals whose preferred candidate has never won an election. So how are you suggesting that they don't have the same constitutional prerogatives as people who just happen to always vote for the most popular candidate?
I think we have to look at what this particular map did to see that the answer in this case is actually quite simple. That the way this map was drawn altered the natural state of things and was so deliberately drawn so that people who once had that power no longer had that power simply because of the way they voted in the past. And I think maybe that gets to Justice Biles's statement about the issue of retaliation as well.
Would that suggest that the persons in the old districts who did not prevail were at that point in time having their constitutional rights violated?
What we have to look at here, and I think perhaps turning to the district court's articulation of the test of an intent and effects test. So I think the question that you're asking is getting only to the effects, and here there is a finding of intent as well that I think is relevant to that consideration. It is what did the legislature set out to do in the drawing of these lines, and what did they accomplish with that being their intent? And that is what the district court found here. So I do want to take just a minute to talk about the racial vote dilution claim as well. And I'm happy to answer any other questions on the partisan gerrymandering claim as the justices have them. But to speak specifically about the racial vote dilution claim, I think it's very important to note here that the court did make this finding of intentional race discrimination. That's a very powerful finding that the court said was based on substantial evidence that was before it. So both expert evidence as well as lay witness testimony from leaders in the different communities that were affected by this map. It is beyond dispute that intentional race discrimination violates the Kansas Constitution. And the evidence conclusively showed that the map literally splits minority Democrats from non-minority Democrats in such a way that minority Democrats have even less of a chance, virtually no chance, of electing their candidate of choice. And that's the essence of a racial vote dilution claim. They were moved out of Congressional District 3 and into Congressional District 2, where their votes, I believe, as one expert put it, will border on electoral irrelevance. And the way that the court looked at this is comparing the treatment of those minority voters who were moved out of CD3 and into CD2 with the individuals who are left behind in CD3. Now, the minority individuals left behind in CD3, their vote was not as deeply impacted, but was still substantially impacted. And in comparing the line, just even looking at the map, you can see how clearly the map splits Democrats from Democrats and moves minority Democrats out of CD3 and into CD2. And that's a classic racial vote dilution issue because CD3 used to be a performing minority crossover district where minority voters in Wyandotte County could work with non-minority voters in Johnson County, northern Johnson County, and elect their candidate of choice. And what the district court found here is that the legislature specifically knew that and then took a look at that community and divided it in such a way that those minority voters in Congressional District 3 would be moved out of the district and have their votes completely diluted in Congressional District 2.
Was there any fact finding about how the various party affiliated and racially classified groups actually voted?
Yes, so there was analysis done by the experts, and I believe Dr. Collingwood's analysis here is particularly relevant.
But did the district court make any fact findings? It's like, I'm just pulling this out of thin air, the registered Democrats in the district voted 80% of the time for the Democratic candidate.
Yes, so Dr. Collingwood's analysis looked at racially polarized voting and found that racially polarized voting occurs in both Congressional District 2, Old Congressional District 2 and Old Congressional District 3 in the vast majority of elections.
And was that a fact finding made by the district court?
The district court credited Dr. Collingwood's analysis in that regard, yes.
But didn't make a fact finding with respect to like concrete numbers, for example, like percentages and so on.
That I would have to go back and recheck the record, Your Honor, but.
And do we need that to evaluate whether or not what you allege is happening is actually happening? In other words, do we need more than just party affiliation? Do we need actual voting numbers, fact finding about who different people voted for?
So I believe with the court crediting the racially polarized voting analysis that the expert did, the court was engaging in that factual finding. So crediting that analysis, accepting that analysis as true based on the testimony that the expert gave and weighing the credibility of the expert, crediting that analysis, I think gives you the factual finding that you need in that regard.
If that fact hypothetically was different, let's say it was the inverse, that there was an affiliation with the Republican Party with minority voters in that district, would we still have the same problem with how the map divides it up?
For the purposes of doing
for the race claim, I should say specifically, sorry.
Okay, so if there was I just want to make sure I understand the hypothetical. If there was a factual finding made by the district court that there wasn't racially polarized voting,
Correct.
I think it would be harder to make that call. But we have that factual finding here. There was a finding that in the vast majority of elections in both CD2 and CD3, there was that racially polarized voting. And so the movement of the minority voters out of CD3 and into CD2 made it so that they could never have the opportunity of electing their candidate of choice.
But even though it's hypothetical, doesn't that illustrate that what, if anything, partisan affiliation predominated the intent of the legislature as opposed to race?
Well, so I think that perhaps this is an opportunity to clear up some confusion on what the claim is that the plaintiffs actually raised in this case, which was one of racial vote dilution and not of racial gerrymandering. And they're analytically different. The Supreme Court has said they're analytically different. So in a racial vote dilution claim, the court did not need to find that race was the predominant motive in the drawing of the maps. It needed to find that it was a motive, one of the motives. So it's internally consistent with also finding that partisanship was a significant motive in how the map lines were drawn. So the two claims are analytically different, and the claim that we brought here, the district court properly found as a matter of law that we needed to show that it was a consideration, and that the evidence supported that was a consideration.
As opposed to a gerrymandering claim where it would have to be the predominant intent.
That's correct. I see that I'm out of time, but I'm happy to stand for additional questions.
Thank you.
Thank you.
This time the court will take a recess for 15 minutes.
The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess now sitting.
Be seated.
Madam Chief Justice, may it please the court. My name is Lali Maduri from Elias Law Group. I will address defendants' federal elections clause arguments. I'd like to start with something that my colleague from the state just admitted. Defendants just said that the Kansas Constitution can and does prohibit race-based discrimination in congressional redistricting, even under their reading of the elections clause. This is the opposite of what their brief argued, and it's fatal to their elections clause argument because the district court found racial discrimination here. Defendants' elections clause argument, as articulated in their briefing, boils down to a singular proposition. Where federal elections are concerned, this court may not fulfill its duty as the highest court in the state and apply its own constitution. In defendants' view, this court and all state courts must stand idly by whenever the state gerrymanders congressional maps. Their original theory of the elections clause would give the legislature carte blanche to violate the Kansas Constitution and dilute the votes of Kansans in federal elections. But their position is contrary to the US Constitution, its history, binding Supreme Court precedent, and federal statutes. And adopting defendants' position would mean vesting unreviewable discretion in the legislative branch, including discretion used to intentionally discriminate, for example, on the basis of religion, on the basis of gender, on the basis of age, on the basis of property ownership, and the list goes on.
Would it be unreviewable, or would it be unreviewable by state courts under state law? In other words, I don't understand the state's position on the elections clause to be that it's completely unreviewable, only that the review is limited to federal court, basically.
That's right, Your Honor. What the state is arguing is this state would have no authority and wouldn't have jurisdiction to even hear a claim that the legislature has intentionally discriminated on the basis of gender. So the legislature could pass a law that said women can't vote in congressional elections, and this court and the Kansas state constitution couldn't prevent that outcome.
I just wanted clarity on, you wouldn't disagree that it would still be reviewable. You would just have to pursue that review in federal court.
Certainly, and at this time, at least, there are, as the state concedes, at least right now, that's not something that has been previously recognized by federal courts.
Would you say, though, that we would have concurrent jurisdiction?
Well, this court is, sorry, go ahead.
Go ahead. You can, would the state Supreme Court have concurrent jurisdiction with the federal court?
Well, certainly someone could raise a claim under the federal constitution that could be heard by a federal court, and other plaintiffs could initiate claims under the state constitution. So in that sense, there would be potentially concurrent jurisdiction, but the issue here is whether or not the elections clause prohibits this court from hearing any claims under its own constitution. And the answer there is clearly not.
Yeah, isn't that more of a choice of law type of question rather than a jurisdictional one? In other words, piggybacking on Justice Standard's question, we often hear federal questions. We have concurrent jurisdiction to hear federal questions. Why wouldn't we be able to hear that case under federal law?
This court could hear that case under federal law. This court may apply federal law.
But the question is really just, what role does state law play in these disputes? Would you agree with that?
When it comes to the elections clause, that is my understanding of the defendant's theory. Their position is that this court cannot apply state law.
Okay.
And the legislature is free, carte blanche, to violate the state constitution when it comes to congressional redistricting and any regulations of federal elections for that matter.
What do you make of what I at least read as 4 current United States Supreme Court justices expressing a fair amount of skepticism that state constitutional provisions can play any role in congressional redistricting? I'm thinking of Justice Alito's dissents in Moore v. Harper. And I get that it's only 4. Should that play any role here?
No, Your Honor. The law as it stands today is quite clear, based on 100 years of Supreme Court precedent, that this court has not only the right, but the duty and obligation to review this case. What the Supreme Court may do in the future is not relevant to your decision today.
So we shouldn't be in the business of predicting what might happen on review.
That's exactly right, Your Honor. And at this time, as you're well aware, no majority of the court has ever endorsed that position. And the court has cautioned against that sort of tea leaf reading, and says specifically that lower court should follow the cases that bind it and leave it to the Supreme Court for overruling its own decisions.
And if I understand the appellants, I don't know if you would call it a concession, but explanation, they would also agree that state law could apply under the elections clause to the extent it defined the lawmaking powers of the state legislature.
That's right, Your Honor. The defendants do draw a distinction between what they say is sort of procedural compliance. So, having the right number of votes in the legislature or submitting something for veto versus what they would term substantive provisions. But that distinction is one that is not supported by anything either in the text of the elections clause, the Supreme Court's precedents, federal law, or any other authority.
You answered my follow-up question, which is just that. Yeah, what textual basis, if any? It sounds, your position is there is none.
That's certainly our position. And most recently, the Supreme Court said in Arizona state legislature, categorically, the Supreme Court held that nothing in the elections clause instructs, nor has this court ever held, that a state legislature may prescribe regulations on the time, place, and manner of holding federal elections in defiance of provisions of the state's constitution. That was an unqualified statement. It didn't say some provisions of state constitutions, but not others. It was all provisions of the state constitution. And if there was any question of that, the second part of the elections clause allows Congress to legislate on this issue, regulate federal elections, should it choose to do so. And Congress did just that when it enacted 2 U.S.C. 2AC, which the Supreme Court interpreted in Branch v. Smith, and it considered this exact issue. That provision requires that congressional plans must be enacted in, quote, the manner provided by state law. In Branch v. Smith, Justice Scalia explained in the controlling opinion that the word manner refers to the state's substantive policies and preferences for redistricting as expressed in its state statutes and constitution, among other things. In doing so, Justice Scalia specifically considered and rejected this exact argument that the manner meant only process or procedures, things like vetoes, things like a commission, rather than substantive requirements. Instead, he explained that the word manner refers to the state's substantive policies and preferences. But that distinction simply has no basis. If not, I can briefly wrap up. Your Honor, the defendant's position impinges not only on the constitutional function of courts, but also on the very sovereignty of this state, which established a constitutional system in which this court, as a co-equal branch of government, has the power to review and, when necessary, strike down acts of the legislature when they violate the state constitution. To read the federal constitution in a way that limits this court in its power to remedy violations of its own constitution is contrary to bedrock notions of federalism embraced in that constitution. And it's repugnant to the sovereignty of states, the authority of state constitutions, and the independence of state courts. Ultimately, defendant's argument is as unsupported as it is audacious. No court has endorsed their radical argument, and this court should not be the first. Consistent with nearly 100 years of US Supreme Court precedent, federal law, the text of the Constitution, and basic principles of federalism and the separation of powers, we ask the court to reject defendant's arguments and affirm the judgment of the district court. Thank you.
Madam Chief Justice, and may it please the court. I'm Steve McAllister. I'm representing the Frick plaintiffs, which is the group who are residents of the city of Lawrence and Douglas County. My clients have brought only a partisan gerrymandering claim, so not any kind of racial vote dilution claim. And their claim is regarding the drawing of the boundaries for congressional districts 1 and 2, so nothing to do with District 3. The Kansas Constitution, as this court has so eloquently and yet simply said, is the people's constitution. And this court is, in important respects, the ultimate protector of that foundational principle. The Ad Astra 2 map, what it represents, threatens to undermine the people's constitution in violation of the Kansas Bill of Rights and Article 5's right to vote. In particular, when the court is asked, where does the ban or the prohibition on political gerrymandering come from? I would say the primary source is Section 2. But it does, as my colleague suggested, work in conjunction with Section 1, as this court has recognized recently in the Hodes and Hauser case, but almost 60 years ago in Harris versus Shanahan. The court cites Sections 1 and 2 in recognizing a fundamental right to vote. The fact that this is a political context all the way back to Baker versus Carr does not mean this is a political question that the court cannot decide. And if you look at the powerful language of the Kansas Constitution, there's nothing remotely like it in the US Constitution. So the fact that the US Supreme Court chose not to recognize a partisan gerrymandering claim in no way controls this court. All political power is inherent in the people, and all free governments are founded on their authority, are instituted for their equal protection and benefit. Equally powerful is Section 3, which the bench has already mentioned. Again, nothing like it in the federal Constitution. It was proposed as part of the First Amendment, but did not make it into the final language. The people have the right to assemble, to consult for their common good, and to instruct their representatives. Those are unique and distinctive provisions in the Kansas Constitution. Going to Justice Biles' point, what are you looking for here? Well, I want to combine his questions with Justice Stiegel's questions. It's not a rule of proportionality. It's not because you have a certain percentage of voters of this party or that party, they get to elect that percentage of representatives. It's about equal treatment. You have to start with a baseline. The baseline is the map we had and the map we're going to. You look for that invidious discrimination, Justice Biles. You look for that targeting, which also can bring in Section 11 of the Kansas Bill of Rights, which is freedom of speech. People being targeted for their political affiliation, essentially, exercising their right to vote, arguably under Article 5, Section 1. It's not a rule of proportionality, though. You're looking for targeting of groups that were in a position where they had a meaningful opportunity to participate, and that is being taken away. That takes us back to sections 1 and 2. That is the equal protection aspect of the case. The Green Party and Libertarian voters are never going to elect anybody, but they're not entitled to 1% or 5%, but they're not being targeted by the legislature in any way. The Democrat who lives in Hays, Kansas, in the Big First, is probably never going to have a Democratic member of Congress, but they're not being targeted by the legislature when it redraws the map. So the first element of the claim here is a predominant intent target a group, and I can talk about the groups that might be protected, that cannot be explained or is not explained by the legislature. And here we have specific findings by the trial court that the reasons offered were pretextual. KU and K-State should be together. That's why we drew this diabolical golf hole looking kind of first district where Lawrence, it goes around counties and scoops out Lawrence to put it into the Big First. KU has as many, if not more, connections to the east in Kansas City with the medical center, the Edwards campus, as it will ever have with Kansas State. Judge found that was pretextual. And then the third factor, and this again relates to the Green Party and the Libertarians, is a substantial diminution in the influence of these voters in elections in the political process. Those voters, if they could get to the point of showing that, could bring a claim. But what we have here is we have Lawrence voters, almost 100,000 of them, who had some competitive elections in the second district. And certainly within my memory have had at least one Democratic member of Congress. But now they have been very deliberately targeted because of their votes, and it could not be.
But was there any fact finding on those votes?
On the city of Lawrence, there's fact
On
finding
those
about
100,000 people?
on the demographics in terms of their
Their
registration.
fact finding on how they voted?
I don't know that anyone has that information necessarily, but
And
there
don't
is-
you need that to
I
make
don't
the
think-
argument you're making?
I don't think we do, Your Honor. The legislature didn't need it. They had they knew what the registration numbers were. They know what Lawrence is.
Let me ask a related question. Do independent voters have standing to bring a gerrymandering claim?
Potentially, if they are targeted as a group.
Well, how would you ever prove up that if, so the claim seems to me to rely on this inferential jump. How you're registered equals how you vote. And you just admitted there was no fact finding on how these voters actually voted. We only know what their registrations were. And if you talk about independents as a class, and I think independents are roughly equal in terms of registration.
Statewide, they are
Statewide.
certainly.
But those independent voters, you lose that inferential jump because by nature of being independent, the idea is, well, they may go one party.
That
the
might
other
make a
one.
difference if you were relying solely on independent voters for the partisan gerrymandering claim. But in Lawrence, you're talking about Democrats.
But doesn't that undermine this inferential leap that you're making? That just because a person is registered a certain way means that's how they vote.
I know that's an argument that's been made, but with all due respect, no. I think it's a common sense inference. It's the inference the legislature, I'm confident, relied upon in this case. There was absolutely no reason to take all of Lawrence and move it into the Big First.
There's at least discussion in Supreme Court case law about the folly of trying to use this inferential leap because real life has demonstrated that voters, even when they're registered to a party, have a strong independent streak, and they will vote for the candidate that they think represents them best, regardless of party affiliation.
And yet the legislature, I think the evidence that the trial court did find acted because those were Democratic voters. I mean, it targeted a group and moved them and tried to put them in a district where they would be buried in a sea of red. So if my inferential leap is invalid, then so was the legislature's. But my point is that's what they relied on. And to Justice Biles' point, they targeted a group to try to disadvantage them. Now, your argument is maybe it won't be as effective as they thought.
My argument is more, as a court, don't we need fact finding that supports that inference?
Well, and then I suppose if you want to send us back for more fact finding, we can try that and produce that.
I understood it, the expert testimony. We know how the city of Lawrence voted in the past.
Yes.
And that's where I keep spinning around with this invidious discrimination thing. That makes sense to me. It doesn't make sense to me to try to predict the future, but you can look and see how people voted and where the votes are concentrated. And that is what these computer software programs do.
Yes, among other things, yes. And I mean, it's no secret how the city of Lawrence votes. I mean, there's all sorts of, having lived there, I can tell some of the jokes about Lawrence. So, it's no secret how the city of Lawrence votes. But this court, has the obligation and the duty, as the Harris versus Shanahan case makes clear, to protect the people's constitution. And when they talk about no standards, I have to tell you, it brings back memories, not necessarily fond ones, of being in Montoy in the Gannon litigation, where this court took one word in the Kansas Constitution, suitable, built doctrines of equity and adequacy. It found judicially manageable standards. I think there's plenty of language in the Kansas Constitution where this court can find and build, and we are proposing standards that will work for partisan gerrymandering. I also think this year is an unprecedented action by the legislature. That's part of why we're here. The state, my colleague to my left argues, well, even in 1859, they were gerrymandering. As we said in our brief, well, thank goodness they were. They were keeping the pro-slavery forces out of power. But that doesn't mean our notions of equality and what's acceptable do not evolve over time as we come to understand what's important and how people should be treated. To me, that's one of the lessons of Hodes and Nauser. There were prohibitions on abortion in 1859, and Hodes and Nauser reached a very different result under sections 1 and 2 of the Kansas Constitution. This is a similar kind of situation in the sense of our understanding of the evil here can and has evolved over time.
Well, it seems to, I get back to trying to deal with hard numbers, and we know what population needed to shift in order to fix the equal population issue, and maps that we have 334% more people. So something's afoot.
Yes.
And might be good, might be bad, but something's afoot here.
Yes.
And let me get to the question that I asked. Am I being too myopic, but am I, by focusing on invidious discrimination, just treating people differently because of the way they acted in the past, and this is government, am I putting too many guardrails on your argument?
I don't think so, Your Honor. I mean, with a caveat. I think in terms of that first step of the standard, the intent or the predominant intent, that is common to equal protection analysis, that you're looking for that invidious intent. Where we would strongly disagree, again, with my colleagues to the left of me, that it's limited to malapportionment or racial. I mean, the point about religion, how could that possibly be constitutional under the Kansas Constitution? Gender, how could that possibly be constitutional? Age, disability, perhaps sexual orientation, military veteran status. I'm not trying to say there's going to be a host of cases, but I do think the Kansas Constitution protects the people from that sort of targeted discrimination. And I don't see that partisan cannot or should not be on the list of what could be protected under the Kansas Constitution when there is targeted invidious discrimination. And again, the other piece we have acknowledged all along is that there has to be effect. So again, I suppose you could have targeted discrimination against the one Democrat in far western Kansas, some small county, but if it's not going to make any difference anyway, I don't know that there'd be any partisan gerrymandering claim. So we're combining the invidious intent and targeting with proof of a substantial effect.
I've been trying to figure out the harm aspect of this and really have wrestled with it because notion of community of interest seems to be element of harm. I mean, Lawrence is a part of Douglas County, and you get ripped out of there and attached to the same people that are voting in Morton County. So that seems to be a harm toward the community of interest there. And that's why I asked the question about, well, why keep Johnson County in one piece? Apparently there are benefits to being kept intact. And those benefits are denied to Wyandotte County and to Douglas County.
There are.
The question is why?
Well, I mean, among other things, they often have overlapping interests. So that Lawrence is not unified, Wyandotte is unique with the unified government where it's a single government for county and city. But there, if you're splitting Wyandotte, you're actually splitting a unified government for the county into different districts. But even in Lawrence, you have the county commission and the city commission, which often work very closely together on many things and might have similar interests with respect to their members of Congress, but are no longer going to have the same members in the sense that at least part of the county commission's jurisdiction is now represented by the second, but the city of Lawrence is going to be represented by the first. So there is an impact on those communities of interest being split for certain.
What is the showing that's required on the effects side then? I mean, isn't there ultimately have to be some impact on the group's ability to participate in the political process?
Well, I think, Your Honor, a couple of things. One impact is certainly the potential, at least, to have competitive races to potentially elect candidates. I don't think we're asking for a guarantee that you elect the candidate of choice. Again, it's not a proportionality request or theory here. And we know that when Lawrence has been in the second, it has both had competitive races, and at least once that district has elected a Democratic candidate. That will never happen. I mean, I'm a lifelong Kansas and I grew up in the Big First. That will never happen in the Big First unless things change dramatically. And the judge made findings about that. The other little more subtle evil to this is you take a place like Lawrence, which has wonderful diversity, activity, and you put it in the Big First, and you've now essentially perhaps discouraged a lot of people from the kind of political engagement, at least at the federal level, that they otherwise likely would have participated in. I know that's harder to quantify. I may not satisfy Justice Stegall on that, but the fact of the matter is you've got KU students, you've got KU faculty, you've got a lot of people who are politically interested and politically active, and when they know they can never really influence and certainly not elect a member of Congress from the Big First, That certainly can have impacts on registration. It can have impacts on activity. It
Is
can
this-
have impacts in more subtle ways.
Is this just a numbers game then? And what I'm thinking of are I'll use the term red, since you use the term red versus blue, the so-called red voters in Lawrence, by the logic of the argument, are actually they gain a benefit by this. Is it simply that there are not as many of them, and so the Constitution favors the group that has the higher number? So it's detrimental to the blue voters, but it's beneficial to the red voters, and so therefore we can't do it because there's
No,
more
I
blue?
think, Your Honor, there's never going to be a proportional equality of the vote in the sense of everyone has a statistically equal chance to elect the representative of their choice. I get that proposition. What we're arguing, though, is what's prohibited by equal protection principles is the specific
The targeting.
targeting for the detriment. So the red voters in Lawrence simply get an incidental benefit. The goal is not really to benefit them.
It's really an equal protection claim. It's not a right to vote claim.
Yeah, it's certainly.
You might have those in.
The right to vote is
orbit.
part of what, implicates equal protection, but it's certainly not a proportionality
So
claim.
along those lines, what level of review or scrutiny do we apply? Is a partisan affiliation a protected class? Do we have any case law that says that it's a protected class?
I don't think you have to say it's a protected class necessarily. I think you have to say that the right to meaningful participation, at least, again, and we're using as a baseline, you go from the previous map to the new map. I mean, we can't go back and just start fresh and say there's no maps in Kansas. And if we knew what the breakdown would be between parties, here's how we would draw districts. We've got to start with a baseline, what we had, how has it been changed, and why has it been changed? And so for these purposes, I don't think it's really about suspect class. I mean, Harris versus Shanahan, I think, does talk about applying the strictest scrutiny if you're infringing on the right to vote. That's not really the way we've articulated this test.
Right,
You
if
certainly
it's-
could.
If it's an equal protection claim, I mean, that's the way at least we are used to thinking about equal protection.
You
is
certainly
What's the
could,
classification? and
But
based-
partisan gerrymandering is a little different, and I think it could be treated differently because unlike things like, race at least, and probably gender, it's not, as you've already sort of pointed out, it's not necessarily an immutable characteristic, so you might not treat it quite the same way. People can change their affiliations. But I think something, taking from the federal voting rights cases, a predominant intent standard, even if you want to mount healthy mixed motive where legislature can try to offer explanations, but the court finds their pretext. And then the burden on the plaintiffs to show there's some substantial diminution in terms of the effect on their ability to participate meaningfully. But it's a diminution in an effect. It is not that we have to be able to actually elect the representatives of our choice. Again, it's not a proportionality claim. It doesn't try to reach that far.
There's some factors that trump other factors. I think we start with the premise that one person, one vote trumps probably everything. But that then constrains how you apply everything else. But is number two dilution of a minority vote? And then community of interest is just like someplace way down
Well, Your Honor, I think it depends a little bit on, thinking in terms of the two levels of law that apply here, which could take us to the other question if you'd like me to talk about that at all. But certainly from a federal standpoint, the US Constitution mandates the one person, one vote. It will also prohibit the racial discrimination, and we have the 15th Amendment. So that will control there. The question we're asking here is what else under the state constitution should be protected? And what I just suggested, I think in response to things I've heard from the bench today, we're asking only for partisan gerrymandering here, but logically, and I think the federal constitution would address some of these too. Religion, gender, those would certainly get pretty harsh review. under federal law, and I assume also under state law. Sexual orientation might also, certainly under federal law. If I recognize Justice Biles' quote, it may have been from Romer versus Evans earlier. You could protect military and veterans' age and disability, which might not be suspect for equal protection purposes, but you might want to at least have the door open under the state constitution if they decided, for example, that we want to put all the young people in districts where they can't influence anything because they don't know enough about politics, and we don't like the way their votes are going to go, or the young are too persuadable towards Democratic or Green Party or other influences that we don't like. So we're going to draw lines based on age.
But why isn't it more harsh than that? Because that gets back to my very first question this morning, or one of my early questions. How is partisan gerrymandering a legitimate government function? And you have, I mean, if you don't have a legitimate government function, don't play around with any of this other stuff.
I would agree with you, Justice Biles. I won't argue with you on that. I don't think it is legitimate. I don't think there's any, to say that it's gone on for a long time and it seems inevitable doesn't mean it's legitimate at all. And that's why I think this notion that we'll just leave it up to the representatives because they're elected by the people. They're not serving the people here. They're serving themselves. I mean, they're drawing districts to solidify their positions. They're drawing districts not to further the people of Kansas, but to further their particular party. There's already a supermajority. They're trying to gain an even stronger hold on that. That's why I started with the People's Constitution and why I'm imploring this court to remain the protector of the People's Constitution. I don't think the partisan gerrymandering has a legitimate interest. I don't think it's justified as a matter of reason. I understand it as a matter of practice and the natural desire to protect oneself and to serve self-interests. And I see how it occurs in the political process, but I'd be hard pressed to make a moral argument for why it's in the public good or in the people's interests.
Well, even a function of God. I mean, why does why can government promote one political viewpoint over another? And that's what this is. That's what partisan gerrymandering is.
I mean, fundamentally, that's what it is. Yes. I mean, I will concede at some level. I mean, there is consequences to elections. So, the winners of elections do change policies or do things. And that's certainly happened with the most recent administration. So they may take different positions than the prior one. But in terms of affecting people's ability to participate meaningfully in the political process, I don't think that's government's business. Government should be in the business of ensuring the widest possible participation, not trying to put people in districts where it won't matter.
That just starts to sound more and more like a proportional type argument.
When they target people.
Well, so I understand your targeting argument, but let's, for sake of argument, say there's no targeting. But Justice Biles' question still is a valid question.
Under my test, that we proposed, a lot of partisan gerrymandering would not be unconstitutional. But if the court is willing to say, look, it's rational basis review, it's not rational to engage in partisan gerrymandering, we accept that. I'll embrace that.
And if that's the case, could you provide a definition of partisan gerrymandering?
Targeting with party in mind.
Well, I thought targeting was separate.
Okay,
We just said that.
okay, drawing lines with party in mind. If you're going to go to a rational basis test.
Okay.
Drawing the lines with party in mind.
Again, how would an evil-minded legislator who wanted to favor his or her party go about accomplishing that?
If the rule was what?
That they could do whatever they wanted.
If they do whatever they wanted, they do what they do in this legislature. They have the authority. They create the map in secret. They present it where they know they have the votes and say, here's the map. Anybody want to say anything? Well,
so they get a map, which again, the argument is will foreclose the minority party from ever winning. Is that a fair statement?
yes.
And I guess isn't that, let's take Wyoming, for example, where there is no redrawing of districts. They got one congressperson.
What a great process, yes.
Is the minority party's rights just being violated there? Because
No, because I think, again, that's, you have to start somewhere with a baseline. And the baseline is Wyoming is what it is when you have.
what if the
the state.
legislature just took Kansas and went east to west and just like, we're going to draw a straight line. We're going to draw 3 straight lines and it's going to create 4 rectangular districts. And we're just going to move east to west. And when you hit the population, 1/4 of the population, we draw the line. You go, when you hit the next quarter, we draw the line.
Well, I think
That
that
passed
might
muster.
well pass our test. I mean, and it might pass Justice Pyle's test. I'm not saying it's his test, but it might pass even rational basis. If it is just, we're going to ignore parties, we're going to ignore communities of interest. We're just going to do 4 districts that look nice. They are contiguous, they're compact, and they have equal population, and we don't actually know who's in them in terms of their party interests. Now, that would not be irrational, and it would certainly not be partisan.
And even if it resulted in 4 districts that had roughly the same proportion as the state as a whole, that'd be fine.
That would be a sort of an incident consequence, I assume, of that.
Seemed to me this case from that standpoint, because of the district court's finding of civic intent or targeting.
Yes.
I don't know how I'd feel if neutral factors were put into that algorithm and
Right.
it spits out, and we have expert testimony about how many variations you can get on that. But I don't know how I'd feel about this if it wasn't for the targeting.
Well, and I think that's kind of in many ways, the linchpin to our claim, showing the change. It's not that the voters of Lawrence, again, it's not a proportionality saying they have an entitlement to a certain representative or a certain weight of influence, but it's the fact that where they were and then where they are and why did they end up there? That's the linchpin, I think.
Counsel, you've completely discounted the theory that that the purpose was to put K-State's interest with KU's interest. But if you assume that was a genuine consideration, aren't you then talking about competing policy considerations and asking the legislature to guarantee that one policy is better than another?
Well, again, if you assume that, and that's why the test I proposed says not just intent, which to some extent subsume that question, but also an opportunity for the legislature to explain, which it did not really avail itself of here to the limited extent its lawyers did at the trial. The trial court specifically found the reasons offered were pretexts. So I'm not saying there couldn't be a case where if they had some actual rational reason for moving Lawrence the way they did, that might be a different case, but they've offered 0 on that point.
So the pretext is simply because it was based on an argument and not an explanation the legislature could have given but chose not to.
I don't think it's just because they failed to explain it, because it's also challengeable on the merits of it and whether people actually believed it or not. But again, it's only something their lawyers offered. It's not something anyone had a chance to cross-examine or challenge actual evidence. And being a longtime KU person, I know KU faces probably more east than it does west.
Well, and your opinion is important, of course.
I know, but it's not evidence.
My problem is that when you ask me to get into the area of looking at policy and making policy decisions, I think, am I stomping on another branch of government inappropriately? I need to know what my standards are such that
Well,
I can
that's-
do what a court is supposed to do.
I respect that, Your Honor. And as one who long argued for the state, I very much believe in the separation of powers. I've certainly been here arguing for the court not to step on the legislature at times. But that's why our test, I think, with the predominant intent, they've offered nothing but pretext, and that those are findings that the trial court made here, that any reasons offered were pretext. And then you have this substantial diminution in the voting influence and the meaningfulness of the voters of Lawrence. I don't think that's stepping on the legislature's toes any more than it was in a case like Hodes and Nauser or others where this court has said sections 1, sections 2, other sections in the Kansas Bill of Rights mean things. They protect the rights of individuals. The legislature enacted a law. Well, of course they did. They did it through a process. It's a majority enactment, but that's part of why this court is the protector of the people's constitution. The legislature has to be held within the constitutional bounds. And that goes all the way back to Harris versus Shanahan, which I would also point out, just in reference to their federal argument, theory, whatever you want to call it. Harris versus Shanahan predated any kind of provisions in the Kansas Constitution about this court reviewing maps. So it's before Article 10. This court took jurisdiction, as it should have, because it should assume under Article 3 that it has jurisdiction of these cases. The mere fact that Article 10 comes along and creates a special process for state maps says nothing, in my view, about whether the court has the power to look at congressional maps. And, I could spend some time, but I won't unless you want to hear it, on why their independent state legislature's theory has a number of holes in it. Perhaps the most important and the simplest, however, I think is a question Justice Stegall asked. There might be 3 or 4 justices who say this would be an interesting question to think about, but this court doesn't follow the opinions individually of 3 or 4 justices who say this might be interesting to think about. It follows the controlling precedent of the US Supreme Court, which for over 100 years has been clear this theory is not the law. And in fact, the Attorney General's brief essentially undermines its own theory with some of the exceptions and qualifications it imposes, which I can't quite make sense of why it makes a difference. For example, if you have a provision in your state constitution that says don't consider partisanship in congressional redistricting, you can look at it then. But if you don't have a provision, you can't look at it. That makes no sense. Bill of Rights can apply just as well as an explicit provision that says no partisanship in congressional redistricting. And just to be clear, as I think my colleague pointed out, one danger of that theory, again, this court doesn't need to really go anywhere near it, can simply rely on 100 years of Supreme Court precedent, is it is not just about redistricting. That's the elections clause. It's times, place, and manner. It doesn't say the legislature draws congressional lines. It says the legislature regulates times, places, and manners of elections. That's everything to do with federal elections that they are suggesting would be beyond this court's purview as a matter of state constitutional law. So I'm at a point now where I enjoy talking with you, but if you don't have further questions, I would wrap up and let my colleague return for his rebuttal. And I would say, just to be clear on remedy, it is certainly our position, not that the legislature, in the event you rule in our favor, is mandated. The court shouldn't be enjoining, it should enjoin the maps. They can't be used. But not that a court has the power or should mandate the legislature to draw particular maps. The legislature can make that choice. So the court can enjoin the maps, might set a deadline for the legislature to consider action. If the legislature refuses or fails to act within that time frame, then somebody has to draw the maps. Last go around, it was the federal court. It's been federal courts before in Kansas history, but there's no reason this court couldn't do it if it ultimately came to that. And I believe that's demonstrated by Article 10. Because the people of Kansas said this court could potentially draw 165 districts. I think 4 is a lot easier than 165. So with all due respect, we would ask you to affirm the trial court and protect, as you have, the people's constitution.
15 minutes.
We've heard a lot of argument this afternoon, and much of it raises more questions than it is answered. Heard that the source of the constitutional right could be the right to vote, or actually it was phrased as the right to vote with meaning. What is that meaning? Who determines the meaning? How is it measured? What is its source beyond the undefined right to vote? Or perhaps it's the provision that puts the political power in the people. What is that political power? How does that apply to political gerrymandering? Has there ever been a standard established by this court or any other court with a similar provision for that? And then just a few moments ago, I believe we heard that any time the legislature has party in mind, it's gerrymandering. But the legislature takes a lot of votes and party is quite often in mind. Does that mean that there's a lot of illegitimate lawmaking going on across the street in Kansas? Or as applied here, there could be no political consideration in connection with the creation of the congressional maps? Something that this court, in connection with the state legislative maps, has repeatedly said is part of a political process. The US Supreme Court has said that it's part of a political process. In fact, it's so political that the US Supreme Court has found that it is a political question that they won't get into. We've heard several times that it's not about proportionality. Russo, the US Supreme Court decision, had it right. The gravitational pull is towards proportionality. When you ask the questions and you get deeper into the claim, it's all about someone, some voter, in this case, Democratic voters, having a better chance to elect someone that they want. Well, that is a gravitational pull towards proportionality. It is more likely that the results of elections will be in proportion to the number of Democratic voters. That is what is actually occurring here. You know, there was a lot of information in the legislative record, to move to a separate point now. A lot of information in the legislative record, and most of it has been ignored in the arguments this afternoon. The district judge acted as if it didn't occur. He said that, well, that was just what the legislature did. Well, the entire legislative record was entered into the record in the district court, and everyone stipulated to it. If you look at the legislative record, you will find that members of the legislature articulated the reasons that they were supporting this particularly map drawing exercise. It occurred in the discussions in the committees. In fact, they even put out a press release and said, these are all the reasons that this is a good map, and it's Defendant's Exhibit 1020. And it lists all of the things that we've discussed here today. The fact that it put the universities together in a district, the fact that it put the military bases together in a district, the fact that Wyandotte County had been split previously and Douglas County had been split previously, the fact that with the rearranged voters, the incumbents would all still win in their districts, even under the new map. All of that was in the record, and all of it was frankly disregarded by the district judge. A few notes about the elections clause. I misspoke if I said that a racial claim is allowed under the Kansas Constitution, and we stand on our briefs on that in the meaning of the election. Race claims, however, can still be heard in federal court. Indeed, it's not as if the plaintiffs in this case have no remedy. These kinds of cases, Congress has specifically provided, can be brought in federal court, racial claims, and one person, one vote claims.
Can you respond to your opposing counsel's argument that we heard that Congress has specifically granted to states the ability to impose greater restrictions or regulations on redistricting.
Oh, so a reference to the federal statute.
Correct.
So that is what I would, I guess, charitably call a cherry-picked statement from the particular case there. The fact is, under the elections clause cases, the court has not extended the right that far.
Well, okay, let's speak more hypothetically then. The elections clause does give a role to Congress, right?
It's right there in the elections clause.
And so if Congress were to say, and state courts have the power to review, let's just say they said that, would that comport with your understanding of the elections clause or not?
Sure, it would be authorized by the elections clause. Congress has acted any number of times. The most prominent one I mentioned initially in the 1842 Single District Act. There was a concern that political gerrymandering was occurring because some states were at-large voting. So they required that there be single member districts. There have been other requirements that Congress has passed over time under the elections clause. I believe there was a contiguity requirement at one point, a compactness requirement at one point. Those are actually no longer in federal statute, but there are very good examples of how the elections clause doesn't permit states to, if you will, trample on people's rights. It actually has the vehicle for the protection of those rights by congressional passage of things like I just mentioned.
I think I'm still confused a little bit on, and I didn't want to talk about this election clause. Still a little confused about what your argument is, and let's use the Florida constitutional provision as an example, because it's got some language in there about something about being not favor or disfavor, saying that under your election clause position, Florida courts have the ability to litigate that question because it's in the Florida Constitution.
Yes.
How does, I don't understand that. If the election clause says that the legislature is responsible for time, place, and manner, then how does state law play into this? I mean, I'm not talking about procedure, but the substantive stuff. How does the state court suddenly get jurisdiction there under the election clause when you're saying we can't enforce our equal protection provisions in the Kansas Constitution?
Because in the Florida situation, the state has brought redistricting into their prescriptions for lawmaking. The phrase the court has used is, what are their prescriptions for lawmaking? And there, the Constitution was amended. And so for redistricting, lawmaking includes those constitutional requirements. There's nothing similar in Kansas. And if you look at those cases, Florida is just one of them. It's called, I believe, the Fair Districts Amendment. Some states, Maryland, has a centuries-old provision about how to draw district lines. Many other states have outright prohibitions on partisan or political gerrymandering. Those are all things that are a direct part of the prescription for lawmaking in those states. That's just not so in Kansas. Kansas, it's a separate Bill of Rights argument that has never been applied directly to redistricting, and certainly isn't the kind of direct regulation of legislative redistricting that all of those constitutional provisions provide.
And what's the textual basis for that prescription of lawmaking sort of carve out under your elections clause analysis?
So that comes directly from the elections clause cases. Specifically, if you go back, you look at the one that allowed the governor's veto Again, it was a prescription for lawmaking. I believe the term is used also in the Arizona case. That there, the districting commission was part of the state's prescription for lawmaking as to redistricting.
Why doesn't lawmaking that violates, Bill of Rights provision? I mean, when the Bill of Rights is enacted and we construe that as a check on legislative power, why isn't that a prescription on lawmaking?
Because here the power is not a state power, it's through the federal constitution. So only the authority that's derived through the power that's coming to the state through the federal constitution is permitted under the elections clause.
But the other examples for the referendums that then at the state level, how, I don't understand the distinction, I guess.
Let me come at it a different direction. So the federal constitution makes distinctions between state legislatures and state governments. And it specifically in this case allocates the power to the state legislature, not to the state or to the state government. And so to give force and meaning to that, and it has to have some meaning, the limitation is that the state legislature has the lawmaking authority as to redistricting or drawing map lines. They may expand or contract that by prescriptions on state lawmaking power, for instance, through constitutional amendments, through statutes, through other lawmaking methodologies, but it's not the state, it's the state legislature.
Right, in a referendum, is that the state legislature or is that the state government?
So that is a change to the state's prescription for lawmaking that the court has found, for instance, as it did in the Arizona case, that was within the elections clause.
Sounds to me like you were arguing prescriptions for lawmaking and adding the words about elections. What am I wrong in that, or?
I don't think that it's simply a concept of the prescription for lawmaking doesn't allow for sort of court enforcement of non-redistricting related constitutional provisions. Because courts are not lawmakers in that instance, as this court often said. The court is applying a constitutional provision or enforcing a constitutional right, which is outside of the prescriptions for lawmaking. Finally, just a couple of more quick points. There were several comparisons in this case to prior cases. The Gannon decision came up. Of course, there was a very specific constitutional provision that talked about funding education. There's nothing similar here. There was a reference to the Hodes decision regarding natural rights under Section 1. This, of course, is not a natural rights case. This sounds more in equal protection, as we've discussed. There was some discussion about the Wyandotte Constitutional Convention. We think that's a very elucidating point about the meaning of the Kansas Constitution. First district lines were also drawn at the same convention that drafted the Kansas Constitution. These were the district lines for the state legislature. There was a tremendous fight over alleged political gerrymandering. The term was thrown around a great deal in 1859. It did not occur to a single one of the folks at that constitutional convention who had just debated the Constitution and then were debating redistricting. In that case, it wasn't redistricting, they were the first districts. Didn't occur to a single person to say, that Constitution we just passed, it prohibits political gerrymandering. And it was a tremendous fight. I would urge the court to look at the proceedings of the 1859 Constitutional Convention. The language is very flowery and entertaining, but it's clear that there was a great deal of emotion involved. And again, it didn't occur to anyone who had just drafted the Constitution to say that it somehow affected or prohibited the kind of political gerrymandering that both sides alleged was going on. There are no further questions. Brief closing comments. Your honors, if allowed to stand, the district court's ruling will have untold future consequences. Having now entered the fray, Kansas courts are all but certain to be pulled into political battles in every redistricting to come. Court should reverse the district court and keep the independent judiciary out of this political thicket.
You know, all counsel for your arguments today. The court will take this matter under advisement. We are now in recess until Wednesday morning at 9 a.m.